Hi everyone, my name is Nandini Nair. I'm an immigration attorney and a partner here in the firm of Greenspoon Marder here in Edison, New Jersey. These are trying times for everyone. Extremely difficult situation for a lot of foreign nationals where they are concerned about their status, they're concerned about the correct way to do things. One of the most common questions I have actually been receiving in the past few days and weeks is, hey, Nandini, I'm on an H-1B and the end client or my employer is asking me to work from home. That address isn't on my LCA. Is that okay? And the answer to that is probably yes, as long as the following conditions are there. The conditions are the following. If your home office location is within the same metropolitan statistical area or MSA, then you should be fine to work from home. What has to happen? Your employer needs to take the LCA posting notice, they have to post it at the home office location, and then they have to update the public access folder. You can also use that same theory and logic if your home is within commuting distance of the work location that was listed on the LCA. Everybody always asks, what's commuting distance? And it's not really like a rigid law or rule, but I always usually say to my clients about 50 miles. I do definitely look at prevailing wages, but roughly around, 50 miles or less than 50 miles, I can make the argument that's commuting distance. So if you're within there and you have to be working from home because of the coronavirus situation, then you should be okay. And nothing further really needs to be done except the posting notice and updating the public access folder. Well, what happens, Nandini, that I do not work or live where my office address on the LCA was? I might, I'm on a new project and I, moved to San Jose, California, but my family is in New Jersey. And I didn't move them and now I'm working from New Jersey. Is that okay? Well, not really. The only option, and it's a very temporary solution that can be used, is that your employer can use what's called the short-term placement rule, which allows you to work in a location that is outside of the MSA commuting distance and not listed on the LCA for 30 days within a 365-day period. It's a very temporary solution. We anticipate that is really not a great option much longer because the reports out there are all telling us that this is going to last much more than 30 days. So what's the situation if that is what we are facing in this crisis? Well, then in that situation, then your employer does need to file an amendment for you to list that home location on the application. There's really no workaround at this point that's given by CIS. There's no grace period. There's no understanding. It's very much business as usual with them. So I'm advising, and I advise all, you to keep that 30-day rule in mind, but also anticipate having to file the H-1B amendment very shortly. I hope this question was helpful to you all. Thank you.